The legacy approach to data architecture treated user information as an infinite, unorganized resource. Applications were built to absorb every possible data point indiscriminately. The GDPR is a massive standardizing force. When data hits the European Union boundary, it's instantly forced into a rigid, organized structural grid. This grid applies to any worldwide entity processing EU residence data, regardless of physical server locations. The core directive driving this framework is data protection by design and by default. By default means the system must be mathematically engineered to assume the most restrictive, privacy-friendly settings the exact moment a user initiates a session. Translating the legal text of the GDPR into functional software requires extracting these first-principle system constraints to build a compliant data lifecycle. Privacy cannot be treated as a post-launch legal patch. It is a foundational, non-negotiable software architecture requirement. We start with a blank system architecture and a single token of personal data. This token represents any information linked to an identifiable person, including names, IP addresses, and cultural profiles. Within this payload, special categories like genetics or health records trigger elevated scrutiny. The system must block these from standard processing, requiring explicit clearance before passing through. Early computing models treated all user data as an undifferentiated mass of corporate property, storing everything together on physical drives. Today, data relating to criminal convictions carries unique, strict processing barriers under EU law that must be separated from general records. Correctly classifying data at the exact moment of ingestion dictates the entire structural flow of the system. Once classified, data reaches the primary decision-making node, the data controller. This node determines the exact purpose and method of processing the data token. Further down the pipeline is the data processor, a secondary execution node that strictly handles data on behalf of the controller. The system's architecture requires a rigid, documented contract between these nodes, guaranteeing the processor only executes the controller's exact instructions. The controller bears the liability of ensuring the processor actually provides sufficient guarantees to protect the data. If the system exports data to a non-EU processor, the GDPR protections must travel with it. The architecture requires adequate safeguards or specific contractual clauses for the transfer to execute. The GDPR modularizes legal liability exactly like modern software microservices. Each node must be strictly defined and bounded. The default operational rule of the GDPR is that data processing is inherently unlawful, unless the data token successfully passes through a lawful basis gate. Consent is a primary route, but the system must build alternative routing gates: contractual obligation, legal obligation, vital interests, and public interest. The final gate, legitimate interest, allows operational processing, but it slams shut automatically if it seriously impacts the user's fundamental rights. To utilize the consent gate, the engineering requirements are strict. It demands an affirmative, unambiguous action. A pre-checked box is a structural failure to secure consent. Before the gate opens, the system must deliver a transparent information payload, clearly stating who is processing the data, why it is being processed, the legal basis, and retention timelines. The architecture must also support absolute reversibility. Withdrawing consent must be engineered to be exactly as easy as granting it. These structural gates eliminate the practice of collecting data just in case it becomes useful later. Once data is inside the pipeline, the architecture must accommodate asynchronous system interrupts, direct commands from the user that override standard processing logic. Users maintain the right to access and the right to data portability. The system must be capable of exporting their data in a commonly used, machine-readable format. The system must also process the right to rectify inaccurate data and the right to restrict processing entirely while disputes are evaluated. The most demanding engineering requirement is the right to erasure, or the right to be forgotten. The system must locate and absolutely purge specific data tokens from every server and processor node it has reached. There are severe constraints on automated decision-making, specifically when algorithms evaluate individuals for significant events. Unless explicitly consented to or legally required, systems running automated decisions must have a built-in manual override, allowing a human to review the logic if contested. Modern databases cannot function as simple data dumps. They must be highly indexed, searchable environments, where an individual's footprint can be isolated and extracted instantly. This technical capability ensures that user data is only ever borrowed, never owned. Whenever a new system architecture poses a high risk to user freedoms, it triggers a mandatory pre-launch diagnostic known as a data protection impact assessment. This threshold is met when a system processes special categories of data, or when it relies on the large-scale monitoring of publicly accessible areas. The organization must also assign a data protection officer. They act as the internal monitor and the primary contact point for the Data Protection Authority. A DPO is architecturally necessary if a company's core activities involve regular, systematic monitoring or processing special data categories on a large scale. The operational protocols also require a strict tripwire. If a data breach occurs, the system must support notifying the Data Protection Authority within a 72-hour window. If the breach poses a high risk to the affected individuals, the system must also support mass, direct user notification. The final architecture integrates automated, heavily regulated alarm systems engineered to trigger at the first sign of system failure. The final architectural requirement is the burden of proof. A compliant system must generate detailed, inspectable records of its processing activities, transfers, and security measures to satisfy an audit. Small and medium enterprises are exempt from this specific record-keeping burden, provided their processing is not regular, risky, or dealing with sensitive criminal records. But if the documented system architecture collapses, failing to secure the data or notify authorities, the response is absolute. Severe architectural failure triggers fines of up to 20 million euros, or 4% of the company's global turnover. Beyond financial ruin, the Data Protection Authority holds the power to order a complete halt to the company's data processing operations. By enforcing data protection by design and default, the European framework forces businesses to abandon sloppy legacy data hoarding. Under the GDPR, comprehensive legal compliance is indistinguishable from intentional, high-quality systems engineering.